Hi, chat. That's weird. The intro didn't go. Huh. What the hell happened? It's dented. I don't know, chat. So, sorry about that. But no, like, the countdown should have gone. I don't know why it went. Yeah, the final countdown is 0. Oh, well. I don't know, guys. It happened, so whatever it is whatever it is. Much as I hate that saying, it is what it is. So, Territory says, happy 40 years and 2 days. Thank you. So, guys, welcome to the show tonight. We are live, and we're talking about, at the end of the week last week, Trump got 2 big old victories against Judge Boasberg. And I think this just highlights more of the scumminess of the federal courts. And once again, I said, it's a judicial assault. They are the coup, and we've talked about this. I think I don't know if Ryan, when I was talking to Ryan Mullally, I don't know if he agrees with me as much as I was saying there. I think he probably agrees the courts are getting out of line, but they are getting very out of line. They are the threat on democracy at this point. They are. This is the one branch threatening the entire institution. And Judge Boasberg is no different. He is part of this. He is part of this problem. And it needs to be addressed. And the district court, the D.C. Circuit Court of Appeals, they have come in and actually pretty fucking effectively here, in 2 separate things. So we're going to get to that here real quick. It's an extrajudicial assault, maybe. Yeah, I think that would actually be a fair way to look at it. But, it's funny. Everybody out there screaming about the rule of law. I'm like, okay, well, other courts are saying this is violating the rule of law. And we've got problems here. And, we need to address it. Now, if you guys don't remember who Judge Boasberg is, Judge Boasberg is a judge in the D.C. District Court. He is the chief judge for the United States District Court. He was appointed by Obama. And here is, if you guys haven't seen him before, this is him. I'm going to put up a picture just so you guys can see him looking like a little weirdo, as he is. Boasberg? No. Boasberg. But anyways, here we go. This is him. I do love these. I love the cope here from the Washington Post. How the White House wriggled out of contempt. Did it really? We're going to get to this. It didn't wriggle out of contempt. The courts of appeals are like, you can't fucking do this, chief. And they said, you ain't got, this ain't for you. This ain't for you, man. So, yeah, there's a big ass whooping coming here. Now, before we get too far into this, we do want to address, and I know, guys, it's been a little while. I know you guys were wondering, guys are like, hey, we're going to do more Trump stuff or political stuff. And we are tonight. It's just, got to find the timing. And yeah, but this is a bit of hilariousness that if you guys want to warm your heart tonight, this will warm your heart. I promise you. This is just, and this is something here that I think you guys need to see. So you guys know Texas is in the middle of its redistricting. And one of the people in Texas is the esteemed Jasmine Crockett, who, it's funny, when she wasn't in Congress, she talked very nicely. And now when she's in Congress, she talks like the most ratchet hood mama ever. Well, anyways, Jasmine Crockett's about to have a bad day. So the Texas Senate just passed their new map. And they eliminated 5 seats, including Jasmine Crockett's. And you're like, oh, no. Suffer, Jasmine Crockett. Suffer. So have fun with that, bish. Have fun with that. Look at that beautiful state of Texas. Deep in the heart of Texas. But you just love to see it, chat. You love to see it, don't you? I know I do. Jeremiah Maddox says, do you need to watch my Ben Vogel coverage? I know Ben's did like 3 to 4 videos about it, but unlike Ben, I'm an attorney in Ohio, and you know, I think I did a pretty good job on it because I also covered Bob Vogel's retarded statement and how that looks in court. So if you don't want to, you don't have to. But I think it'll be very good. I think it's very good. So it's up to you. It's up to you. Now, with that said, this is here. Safa Jasmine. Safa. Oh. And we're going to get to now, we're going to move on to one of the first things that happened on the 8th. And this, oh, chat, this is a good one. It's very short and very succinct. But it still is the court addressing some of Boasberg's orders that need to be dealt with. Kel says the answer is yes, watch it. I would agree. I would agree. It's only 15 minutes, but I broke it down. I broke it all the way down. Now, what happened? So this is in the D.C. Circuit Court of Appeals. Remember, the D.C. Circuit has its own, the District of Columbia has its own Court of Appeals. Okay? They have their own because all the administrative stuff, everything that happens there. So it's JGG. Guys, remember, this is part of the group of 5 Venezuelans who claim they weren't part of Trendy Arugula and were not trying to get deported to Venezuela or to CCOT. So what happened here? There were some things that were presented for stays. There were emergency motion stays for pending appeals. And they wanted some things here, not so they said here that the motion supplement the record. Everything else is being released per curiam, meaning that the judges all agreed, we're not doing this, we're done. Now here, what does this mean? They say this case concerns an ongoing dispute over the rights of Venezuelan nationals and alleged members of Trendy Arugula being removed from the United States pursuant to the Alien Enemies Act. In this latest round, the district court issued an injunction ordering the government to facilitate the ability of a class of Venezuelans who had been removed to El Salvador to seek habeas corpus relief. Yes, that is what Judge Boasberg did. Judge Boasberg had decided you have to make these, you have to make happen. These guys in El Salvador, you have to make sure they can seek a habeas petition. Now, they say the government sought an appeal, and they say, while its appeal raised... Now, here's the thing. While the appeal raised serious questions about a court's power to direct diplomatic conduct, we don't have to reach those because the class members have since been released from Salvadoran custody and transferred to Venezuela, where they are not likely to remain in custody. Why couldn't Venezuela take them back earlier? Very weird, isn't it? It's almost like this was all bullshit. So these intervening events have overtaken the rationale. We therefore vacate the district court's order to remand for further proceedings. Basically saying, Judge, it's over. Now, they go on to talk about a little bit more. On March 14th, Trump invoked the Alien Enemies Act to get rid of the Trendy Arugula boys. TDA is a foreign terrorist organization, and the president stated it is closely aligned and has infiltrated the regime of Nicolas Maduro that currently controls Venezuela. But on the evening of March 15th, the government removed from the United States a number of aliens subject to this. It transferred these aliens to El Salvador, which placed them in the prison known as the Terrorism Confinement Center, also known as CCOT. You guys remember that's the place where the they had the drone shots and the guys were getting like frog marched into jail. That's what they did there. Now, what goes on from here? They say on March 15th, 5 suspected TDA members detained in southern Texas filed suit to prevent their removal. They asserted a due process right to notice. And then the district court, this provisionally certified a class of individuals subject to the proclamation, and it restrained the government from moving them. And it says before the TRO issued, 2 airplanes carrying members of this class left the United States airspace. Remember, we had that whole issue about could the judge order those turned back. Most of these individuals were transferred into Salvadoran custody and placed in CCOT. The government appealed and sought a stay, and this court denied the relief, meaning the D.C. Circuit, but the Supreme Court vacated the TRO in Trump versus JGG. Now, remember, they did say that all of these guys are entitled to habeas petitions. If you're in the United States and you're being subject to removal, you have the right to challenge that removal. Remember, that part was 9-0. And they explained that the core habeas claims were necessarily implied the invalidity of the plaintiff's confinement and removal. Court explained that core habeas claims only lie in the District of Confinement, and that means the Southern District of Texas, where they were at. Nonetheless, this court, meaning Boasberg, observed that aliens subject to removal under the AA must, as a matter of due process, receive notice and an opportunity to contest their removal in habeas before the proper court. And once again, the Supreme Court had to do that in Trump, AARP versus Trump. So you do. And remember, they were saying you can't just give them 1 day notice. They have to have reasonable notice to challenge it. And once again, that makes sense. And that's fair. And they say after the Supreme Court's ruling, 7 new plaintiffs, as next friends of individuals removed under the proclamation, joined an amended habeas action brought on behalf of these individuals. The plaintiffs moved the district court to certify a class, and they sought an order for the government to return class members to the United States. And they say, on the plaintiff's telling, our district court could grant this relief because class members were detained in El Salvador, which is not within any federal judicial district. And this is, yeah, I mean, that's the foolishness and the outlandishness of it all. That, well, wait, they're not in America. But you could still do it. You could still do this. And notice how obnoxious these arguments are. The plaintiffs also requested a preliminary injunction to immediately request to take all reasonable steps to facilitate the release and return of members to the United States. They say the district court granted a preliminary injunction. And here, the court held that it likely lacked jurisdiction over the habeas claims of the detainees. It said it explained that in relevant part, the habeas statute authorizes courts to grant relief only to persons in actual or constructive United States custody. And the court found that the United States had neither form of custody over the detainees. The plaintiffs argued that El Salvador was detaining him at their behest. But the district court rejected that argument after jurisdictional discovery, and it concluded that El Salvador had legal grounds for the detentions. Grounds far outside the ken of a federal district court. It says, yet the court construed the complaint as raising a different claim outside of habeas. An equitable claim. Remember, chat, equity is outside of the law. They now handle both, but equity is different from a remedy at law. And that the government violated due process, and they didn't get a notice and meaningful opportunity to challenge their designations. The court concluded the claim need not brought in habeas because it did not necessarily imply the detainees had been removed unlawfully. Instead, success on this claim would grant them only the chance to argue in habeas. Said the court that held the claim was likely to succeed on the merits because the detainees had been removed before they had an opportunity to seek habeas relief. And the court certified a class of all aliens removed from the United States and transferred to CCOT based on the proclamation. And it enjoined the government to facilitate all this. The court invited the government to propose ways of complying with the directive. Notice this shit. Keep fucking around with it. Keep doing things. And remember, every time this happened, every time this stuff has happened, the Supreme Court said something, Boasberg did something else. And Robin Hood says, yes, Rasul v. Bush seems like important reading. That's a Gitmo case. Yes, there are a lot of Gitmo cases. And one night, I think I'm going to do kind of like a list of them. And like, if you guys want to read interesting stuff out there, there's a lot of them that are very critical to read. They say it emphasized the government must take action that would allow members to actually seek habeas relief. And it indicated that would order more concrete steps if the government didn't do enough. So the government appealed and sought a stay. When the motion was filed, the order presented serious constitutional questions. It compelled the government to facilitate the ability of the CCOT detainees to seek relief against the United States in domestic courts, which would have required the U.S. to have custody over detainees. Which, how does that work? Because if you're not in custody of the U.S. government, habeas doesn't mean anything. And it says, given the court decided that there is no custody over them, the order would require the United States to engage in diplomacy to gain custody over the detainees. Yet federal courts likely, and I like how they say likely, cannot order the branch to engage in diplomacy. It can't. You can't order the government to engage in diplomacy or reach specified diplomatic goals. You're not allowed to fucking do that. And it says, while the motion was pending, the Salvadoran government reached a diplomatic agreement to release the 252 Venezuelan nationals from CCOT to Venezuela. It now appears the class members are soon will be free in Venezuela. And it's funny because a bunch of them have been released and like, I like it here. And I'm like, I thought you had to leave. I thought it was so bad you had to leave Venezuela. Why are you okay with it now? Makes you wonder. Moreover, the Venezuelan government apparently has promised not to oppose return of class members to the United States under certain circumstances. They say, in light of these developments, we find that it is just under the circumstances to vacate the order and remand the case for further proceedings. They say the class members transfer from CCOT to Venezuela is such a change. Among other things, the transfer alters the harm. It may also affect the government's ability to obtain custody without having to engage in diplomacy, because now they have to negotiate with another country who's hostile to them and is not their ally. And it may affect or even whether the named plaintiffs wish to continue to press their claims. If doing so would require them to submit to U.S. custody. Yeah. I mean, like, okay, fine. You want to come argue your habeas claim, you're going to have to get shackled up and put on a plane with ICE. Do you really want that? And they're going to be like, oh, no, los míos, ay. Like, no, they're not going to want that. They are not going to want that. So you got to take it. You got to take it, chat. And they say more plaintiffs do wish to proceed. They may be required to adjust their habeas claims to account. For its part, the government contends a transfer rendered the action moot. And they say, under these circumstances, it would make little sense for this court to review an injunction that has been overtaken by events. So we vacate the injunction and remand for further proceedings. We express no opinion on what kind of class or relief, if any, may be appropriate in light of circumstances, because that's outside the issue that we're doing. But it's per curiam. It's so ordered. All three of them say this is a disaster. Once again, another judge causing fucking problems. Judge Boasberg again. Then from here, chat, we get into some of the biggest stuff. We get into the big thing, the BTFOing from the same case. And it's a little weird how this keeps happening, but there's another case that's part of this. And this is also filed on August 8th. Robin Hood says, how does a federal habeas work? I mean, you file a habeas petition saying, I demand, normally you're filing it as the prisoner yourself, you're in custody, and you're like, I demand to be brought before a court. I don't know why I'm being held. Nobody's told me. Why am I being held? Present the body and explain why this person is in custody. So the government has to explain why that person's being held. Habeas corpus, produce the body. Produce that person and explain what's going on. Why are they here? Why are they being held? It's very simple. It's very simple. Now, there are habeas petitions where you get to people who are in prison and they're doing their appeal. They're doing like an end run. It's considered they're doing outside of the normal appeal process. So they've appealed and they've already lost. So they're doing they're trying to open their cases back up. That's another version of habeas. But the traditional habeas is, if you got picked up by the police, why am I being held? Nobody said anything. Nothing's happened. I've been sitting in jail forever. You can file a petition for habeas corpus the court recognizes it because it's easy enough. It doesn't cause any harm for the drag this person in the court. Say, hey, government, why are we holding this guy? What's the deal? And the government has to explain why they're holding him. If they can't, he has to be released. But habeas corpus goes back to the time when the king would just put people in jail and that would be it. What happened? Something. What? I don't know. And that's where the habeas petitions would come from. Can they order them present someone who's in their custody? I would argue no, you can't. How do you do that? And the court, the Judge Boasberg recognized that. More importantly, the D.C. Circuit recognizes that. How do you do it? It doesn't make any sense. It don't make no sense. So let's see here. Now, moving on here, guys, this is a big one. Now, notice it says page 1 of 110. We're not going through all 110 pages. We're going through one of the concurrences. That's all we're going to do. But this is also the same case again, JGG et al. Versus Donald Trump. So what is this? It's an appeal from the district court. It's an emergency motion for a stay pending appeal, or on the alternative, a writ of mandamus. Yes, the writ of mandamus. The writ of mandingo, whatever you prefer to call it. So who is involved in this? Who is involved in this is a lot of different organizations. So you can see here, Pam Bondi as the Attorney General, Yakov Roth as the Deputy Assistant, Drew Ensign as the Deputy Attorney General, Emil Bove as the Principal Associate Deputy Attorney General, who is now going to be a judge on the Third Circuit, Chad Mizell, Acting Attorney General, and then August Flenchie, Acting Director. And then you have all these people down here who are involved on behalf of, there's also the Landmark Legal Foundation was involved as amicus curiae. And then there were other parties here who were on the motion to dismiss and the motion to oppose everything. And then we have three judges again, Katsas and Rao, who have been very friendly to the Trump administration. Judge Pillard, not so much. But the opinion of the court was filed per curiam. There was a concurring by Judge Katsas. There was a concurring by Judge Rao, and there was a dissent by Judge Pillard. Okay, so what happened? Well, ultimately, once again, we go back to the Alien Enemies Act thing for the trendy arugula boys. Once again, nothing new there. But now this covers the planes. And guys, remember we talked about this. When the planes were being sent out, Judge Boasberg tried to say, bring them back. And then what did this turn into? What did this turn into? What did this turn into? Well, this is where we get into it. So they talk about that there were the planes going around. And they say that ultimately what happened here was the district court issued an order saying that you couldn't remove anybody else from the country. Well, two of the plane loads had taken off after that had happened. And he held them in contempt, criminal contempt. And the federal government had an option to purge by providing the individual who was responsible for defying the court order. And they had to bring them out to explain what happened on the 15th and the 16th to say, we violated your court order. And then the judges said, I will prosecute this. I will have the government prosecute the contempt findings. And if they can't, I will appoint someone to do it. Now, they point out, here's what happened. So the government appealed the probable cause order and moved for a stay of writ of mandamus to terminate the criminal contempt proceedings. Remember, he held them in contempt. And this is after the government had vacated the orders and said, you can't do shit about it. And this court granted a stay pending consideration. So what happens? Well, the government tried to appeal, and the D.C. Circuit's like, you can't do that. They're unanimous on that point. You can't appeal a contempt like this. They did conclude, though, two of them, remember, you only need 2 out of 3 to win on something, that the requirements for writ of mandamus prohibiting Boasberg from doing something is there. So they think that there is the proper grounds for that. And the judge and Katz starts off by saying this case involves the extraordinary ongoing confrontation between the executive and judicial branches. Now, here's how this works. On March 15th, Trump sought to implement, or the executive branch implemented the presidential proclamation. And they say at least this required precise coordination among 3 different sovereign nations, as planes carrying more than 100 TDA members flew from Texas to Honduras to El Salvador. They go on to talk about how all this happened here. And they say after flights carrying some of the alleged TDA members had exited the United States airspace, the court temporarily restrained the removals. And you know what? It's too late now, is what the government said. Well, the judge said, no, turn them back. Remember, we had that issue. Can he tell them to turn back? They say, according to the district court, the executive branch carried out the removals in defiance of the TRO. I don't know about that. They say in response, the court found that there was probable cause to see that people had violated it. The government's willfully violated the order, and it was criminal contempt. And they point out that it did all this to vindicate a TRO the Supreme Court had vacated for lack of jurisdiction. So SCOTUS had already said, nope, we're not doing this. And Boasberg still pressed ahead. He pressed on. Once again, judges out of control. And this implicates an unsettled issue whether the judiciary may impose a contempt for violating injunctions entered without jurisdiction. Now, remember, guys, at the time, I was thinking, well, the court had made an order, you still have to abide by it. Yeah, and I think the court would have some jurisdiction here, but Boasberg completely fucked this up. He cocked it up bad. So, what happened? So, here's the biggest issue, though, and this becomes a problem for the court. This becomes a problem for Judge Boasberg. At the end of the dispute, there lies a simpler question. By its terms, the TRO prohibited the government from removing TDA members. Well, you can interpret that 2 ways. So if you're given an order and you can interpret it more than one way, how do you know which way you're doing is right? It might have barred the government from simply expelling detainees from the territory, or it might have barred the government from surrendering custody to a foreign sovereign. And everybody agrees the government did not violate the TRO under the former view. That this idea of expelling detainees, they agree the government didn't mess that up. It's the surrendering custody that becomes the problem. And the contempt question boils down to a straightforward meaning and dispute over what removing means. And here's the problem. If an order is ambiguous, you can't be held to violate it. It could mean this, it could mean that. How do you hold somebody in contempt then if they don't know what you mean? And they point out the district court's minute order could have been reasonably read either way. If that's the case, I can't be held to have violated it. Now, they go on to talk about there's no basis for interlocutory appellate jurisdiction. That said, though, mandamus is appropriate because the government is correct about the merits of the complaint and our saying so now would prevent disputes. It would save time. And courts have reviewed interlocutory orders through mandamus to prevent extended inter-branch conflict. Yes. And they say, for these reasons, I concur in the order granting the petition for mandamus and vacating the contempt. Now, they go on to talk about, guys, just real quick, if you remember, for the TDA, and remember the law, these opinions have to explain it all from the beginning. The Secretary of State said TDA is a terrorist organization, and FTO, under the Anti-Terrorism and Effective Death Penalty Act, the AEDPA of 1996. And to support that designation, you must make findings on the record that TDA is a foreign terrorist organization. The organization itself may seek judicial review. And that's a case, the National Council of Iran versus the Department of State. They hired attorneys and they did this in 2001. And the consequences are severe. If you're an FTO and you can't get in the United States, nobody can materially support you. It's providing material support is a crime. And your funds are frozen. And so I talk about on March 14th, the president issued the proclamation directed at TDA. They talk about all the stuff they've done here, and they said that they would therefore proclaim the Venezuelan citizens who are members of TDA, who are at least 14 and present in the United States, and neither naturalized nor lawful permanent residents, are liable to be apprehended, restrained, secured, and removed as alien enemies. Okay, so the proclamation was published one day after its issuance on May 15th. And then what happened? A bunch of these guys got sent to the El Valle detention facility in Raymondville, Texas, near the southern border. The government also arranged to immediately move more than 100 of them to El Salvador. And it's interesting here because they talk about this. As things came up in the AARP versus Trump case, these trendy arugula guys have barricaded themselves in housing units. They've taken hostages. And they say, given these facts, it's unsurprising the government wanted them the fuck out. So what happened? Well, on March 15th, at around 5:25 and 5:45, these plane loads took off. They landed in Honduras at a military base and remained there for a while. Then the flights took off for El Salvador and landed there shortly after midnight on Sunday, March 16th. Awaiting the flights were hundreds of Salvadoran security guards dressed in combat gear. These buses removed them, and they were taken away to the Salvadoran prison known as CICOT. The president of El Salvador saw the operation on his end. Yes, he did. And why is that important to include that? Well, that sounds like a foreign action. The president of a foreign nation's overseeing it? That sounds like it's an El Salvador problem. Hold on here. I think I saw a comment. What are you guys talking about? What you guys are talking about? Yes. Trump and Putin are going to meet in Russia. It's going to be in Anchorage. That'll be interesting. We'll see what happens. Erica says, need a big win today. We're going to get you the big win. Here we go. Here we go, Erica. So what happened? While this was going on, the lawyers issued a suit at 1 a.m. in federal court. Now, if you guys are wondering why they could do that, it's because they could do ECF, electronic filing. So that's why they got away with that. They could do ECF. They could do ECF. That's how they got things in the middle of the night. The named plaintiffs were the 5 individuals. The named defendants included everybody. So the complaints invoke causes of action under habeas corpus, the APA, and principles of non-statutory review. So they point out that the complaint took no issue with Trump's description of TDA as an organization with threats to national security. They say, however, they disputed that TDA was conducting an incursion, and it alleged that none of the named members were TDA members. And that's fine. You're allowed to say that. And they say, over the course of the day, litigation proceeded on an emergency basis. At 9:40 a.m., Boasberg issued an ex parte order stating the government shall not remove any of the individuals from the United States for 14 days. That's your order right now. Do not remove for 14 days. That's order number 1. Pretty straightforward, right? You can't remove them from the United States. I think we all agree what that means. That means the 5. Apparently, the government already placed them on some of the planes, but it returned them to the detention facility. So the government complied. They did a good job. These guys, they continued to detain these 5 individuals within the United States, which is funny because if they got sent to fucking CICOT, they might be out in Venezuela already. Once again, it is very funny. This lawfare has kept these guys in fucking jail. Isn't it ironic? It's very ironic. It's very fucking ironic. It's like, well, how does that work? So given the likelihood of imminent removal flights, the district court did a teleconference at 5 p.m. to further consider interim relief. At that hearing, the court dismissed the habeas claims and provisionally certified a class of aliens. At 6:45 p.m., the court decided to issue a second TRO. So we're on to TRO number 2. Despite acknowledging the hard and closed questions about the AEA, he issued it. The court announced that the second TRO will be appropriate to prevent removal of the class for 14 days. And then what did he say? I will issue a minute order, meaning I will issue a written order memorializing this so you don't have to race to write it down. Okay, so right now it's just an oral order. So what did he tell the government? He says, you shall inform your clients of this immediately, that any plane containing those folks that is going to take off or is in the air. Notice, listen to this, that or is in the air, and we're going to see why this gets changed. Or is in the air and needs to be returned to the United States. But those people need to be returned to the United States. However, that's accomplished whether turning the plane around or not embarking anyone on the plane, or those people covered by this on the plane, I leave to you. But this is something you need to make sure is complied with immediately. Then at 7:25 p.m., the court followed up with a written minute order prohibiting the government from, and now we're the written order number 2. So we have an oral order number 2, but now this is the written order. It prohibited the government from removing members of such class pursuant to the proclamation for 14 days until further order of the court. After this was entered, no more planes departed the country based on the proclamation, but other people were still being deported. Based. And later it got extended for 14 days. The government appealed for a stay of the TROs. This court, the D.C. Circuit, denied relief, but the Supreme Court vacated the TROs in Trump versus JGG. Once again, both of these beginnings kind of cite the history there. And they point out jurisdiction only lies in one district, the District of Confinement, and that's Rumsfeld versus Padilla, which once again is the Southern District of Texas. And then they talk about since this happened, individuals in the United States have filed habeas actions, and the districts where they're confined and courts have afforded temporary relief to the classes. The AARP versus Trump case. There's also an AARP 2 case. Now, guys, in this one here, and this is where Robin Hood, you're asking, what happens with these people? Well, they can say, I am not a member of TDA, prove it. Because the government's going to say, well, you're a member of TDA. And the only way you can really challenge it right now is by having your habeas hearing and say, well, you have to prove it. I'm demanding proof. And the court goes, okay, government, prove it. Now, they keep going there, and they say after jurisdictional, they go on to talk about what was going to happen here. So after jurisdictional discovery revealed there was no such constructive custody, the court nonetheless enjoined the government to facilitate the ability of CCOT to file habeas petitions. And we talked about this in the other appeal that we addressed. Listen to how fucking insane this is. Listen to how fucking insane that is. So they move on and it says April 16th, Boasberg issued an order finding cause that the government officials committed contempt by ignoring the second minute order. And the court concluded that the vacator of that order does not bar the imposition of sanctions. The court reasoned that an injunction can support contempt if the court lacked jurisdiction to enter it, because, and I agree with this, parties must obey even when void orders until they're reversed on appeal. Because until it's appealed, is it really a void order? Although it seems like Boasberg is acknowledging I knew it was wrong. So we keep going here, and we keep on going, and there are some things that he tried to do here. He says the court offered to stand down if the government chose to assert custody over the individuals transferred to CCOT. Remember, this is where he extorted them with the other ruling he made. Well, they can't fucking do that. They couldn't do it. He says, otherwise, it will proceed to identify which government officials made the decision and hold them accountable. He said the court promised a criminal prosecution of those individuals, either by the executive branch or, if necessary, a private attorney appointed by him. And it said the government appealed, and the government wants a writ of mandamus. The plaintiffs moved to dismiss. And then they talk about, big point, while these motions were pending, El Salvador released the class to Venezuela. Now, they do talk about here that a show cause order is not presently appealable. It is not a finalable appealable order under the terms of 28 U.S.C. 1291. And you've heard me talk about that before, chat. You have to have a final appealable order. And that's not true. That doesn't work right now. Contempt is not that way. At least not yet. So what do they move on to? So because that doesn't work, they focus on the mandamus action. And you can get a mandamus action under 3 circumstances. You must have a clear and indisputable right to relief. You must have no other adequate means to attain the relief you desire. And number 3, the writ must be appropriate. And ultimately, guys, as I told you, there's a BTFO coming. So yes, they win on this. But the government presents 3 arguments. The show cause order pressures the executive branch to engage in sensitive foreign policy negotiations. Second, a court cannot appoint an attorney to prosecute members of the executive branch. And third, the TRO was not clear enough to support contempt. Another objection, although not presently advanced here, lurks in the background, is if it's entered without jurisdiction, can you support criminal contempt? So it doesn't make it clear. Now, here's where we go on. They point out that this is going to work. And it says the March 15th order says the government's adjoined from removing members of the class pursuant to the proclamation for 14 days. And here's the big thing. The docket text did not explain what constituted removal. As the district court later counted, one possible reading is a TRO simply prohibited the government from transporting members. On that interpretation, the government didn't violate the TRO. For it's undisputed that the removal flights which departed South Texas were outside of the United States airspace at 7:25 p.m. And for that matter, at 6:45 p.m. And they say, however, the TRO could also have read to prohibit the government from relinquishing custody. And the government relinquished custody. And they say, whether the government violated this turns on a question of what actually is removal. And here's the problem. If there's ambiguity, it must be resolved in favor of the contemptor, who is the person accused of committing contempt. And if you're going to do criminal contempt, the injunction must be clear and reasonably specific. And they point out that overall, others agree the long-standing salutatory rule in contempt cases that ambiguities and omissions in orders redound to the benefit of the person charged with contempt. You know, it's settled law that contempt will not lie for violation of an order unless the order is clear and decisive. It contains no doubt about what you have to do. So how does that work? How do I comply? Well, it's not clear. Once again, we've covered this before. These judges are so much Orange Man bad. These judges are just bumbling out the door to get orders out, and they put out gobbledygook bullshit garbage. How do you comply with this stuff? You can't. We talked about that Rhode Island case where the judge put out an order and the government said, fine, we'll comply. And he's like, no, not like that. No. And then he had to come back and then he had to put out another order. The government's like, we'll comply with that. Fine, we're doing that. No, not like that. This is what's happening here. Yes, it's not ironic. It's just, isn't it moronic? Yes. And they say these rules check the rule of lenity, which applies to criminal cases, and which is ambiguities in law resolved in favor of a defendant. And they bring up a bigger issue here. And once again, we're getting to this lawless judiciary. where a single judge undertakes to set aside the governing rules, prosecute its violations, adjudicate liability, and then impose punishment. You're like, wow. When you think about it, holy shit. Yeah, that's really bad. And the Supreme Court mentions this fusion of legislative, executive, and judicial powers, summons forth the prospect of the most tyrannical licentiousness. And licentious, chat, is a $20 word. That means lacking morals or bounds. And yes, the courts are doing whatever they want. Sounds like it's there, isn't it? Yeah. Judge Boasberg comes out and goes, I am law. And once again, we get back to the joke, chat. The difference between God and a federal judge is that God realizes he's not a federal judge. Now, here's the issue. The plain language supports the government's narrow reading as key to what does expulsion mean. And removal means expulsion. Start with the ordinary term, the meaning of the term removing. And that's where you have to do this. What does this word mean? Well, so these definitions, they talk about these definitions. They connote physical displacement from location to another, which means movement away from the United States into another country. They don't connote anything about custody, nor do they connote any action. And they say statutory context reinforces this. And they talk about, moreover, the AEA ties repeatedly removal to expulsion. Because under the AEA, you are removed from the country. More importantly, the Immigration and Nationality Act. Remember, chat, we're about the rule of law. We're going to rule of law this shit. Likewise supports the understanding of removal to mean physical expulsion from the United States. And there's multiple cases. Removal doesn't hinge on admission or custody by a receiving country. Sometimes it can happen without either happening. Well, if you take an alien to the wrong country, he was removed. And then there's also this court case, I think it's hilarious here, they talk about removal would be affected if they sailed somebody out to the boundary of territorial waters and tossed their ass overboard. That's hilarious. That's based. The Uruguayan and Paraguayan version of physical removal. No, there's just case after case after case here. And they're saying, in short, the government's account of removal finds more support in the case law than does its litigating positions. And to the extent that this may complicate the territorial focus, it only highlights our term that this doesn't connote a transfer of custody with any degree of clarity, meaning it's not clear. And they say, finally consider all the TROs together. The first order was expressly territorial in focus. The second order, referencing neither territory nor custody, was less precise, meaning we were at a narrow point at the first order. At number one, we were here. And by the time we got to number two, look at the scope of number two. It was far wider, chat. So it's not as precise anymore. And there's no reason to think that removing under the second TRO meant something different than the first. And it says the second TRO protected the absent class members up until the transfer in custody. And it says to construe the TRO, the district court looked at the oral hearing, and meaning the oral arguments of the oral orders there. Now, here's the thing. When you do that, courts can look at the context they were entered. But nonetheless, caution is appropriate because you can't dissect sentences if they're statutes. There's another issue. The transcript of the hearing is not available until the next day, after the government had decided to seek decisions on whether or not to keep removing, as it was an ongoing counterterrorism operation that was unfolding internationally and in real time. And it says, finally, the district court reassured the government that it would memorialize the writing. So with these caveats, they talk about it. Once again, we already just covered this part. And it said the court reasoned that not embarking anyone on the plane actually meant not disembarking anyone. And they say that the part of its oral command was not to deplane anyone. And they're saying that makes sense. Although this is garbled, that highlights the pitfalls of trying to understand written legal meanings from transcripts, just because of phrases that are spoken in English, which is not always the most precise. Now, what happens here? The district court also drew inferences based on the first TRO. By its written terms, the TRO merely stated the government shall not remove. Yet in the oral hearing, the court construed the TRO that the planes that are bound for El Salvador would have to be brought back once the planes land. Now, that's what Boasberg says. And the judge is like, no, I see that differently. He's saying, I interpret this as, and this is the circuit court judge, the oral command established by its terms, the comment, the first TRO, confirms the ultimate action that was orally required was to return the detainees to the United States. But, and here's the big thing, the written order excluded all of that. You know, the judge's oral order was super huge and saying return the planes. But his written order said nothing about it. Why? Well, the circuit judge is like, this is for a good reason. Judge Katz says it's important. First, each of these options were problematic. First, in order to bring a member of a foreign terrorist organization in the United States would have faced an objection that the judiciary cannot override statutory prohibitions on the admission of aliens. Legally, you can't force terrorists to be brought into America like that. Second, and this is where it gets interesting, guys. We're going to talk about this case real quick. Any freestanding order to turn planes around midair would have been indefensible, akin to the single justice order set aside by the entire Supreme Court for the executive branch to stop bombing Cambodia during the Vietnam War. In its case, a Holtzman v. Schlesinger from 1973. Now, you'd think Judge Boasberg would know about that motherfucking case. Why doesn't Judge Boasberg know about this? And if you guys don't know what Schlesinger versus Holtzman is, so in 1970, during the Vietnam War, Richard Nixon went into Cambodia. Because in Cambodia, well, here are guys. Google Maps. We're going to do it on the map, on the map, on the map. Maptastic. And no, this is not an NLO episode, chat. Even though it sounds like it. All right. So, guys, remember, there was at one point 2 Vietnams. There was a North Vietnam. And then there was also a South Vietnam. And this is South Vietnam. Well, the Ho Chi Minh Trail would run along. The Ho Chi Minh Trail was a supply route through Laos, Cambodia, and from there it would go into Vietnam. And that's how the North Vietnamese and the Viet Cong supplied themselves with the Ho Chi Minh Trail. This is where, if you guys have ever heard of Mac v. Sog, there were Mac v. Sog teams running loose in the jungles of Laos, in Cambodia, going into North Vietnam, going into the highlands. And those teams were meant to penetrate and do reconnaissance and figure out what's going on, how do we attack and stop. Well, eventually, Richard Nixon became president in 1968. And by 1970, he said, we're going to invade Cambodia. So the U.S. military invaded Cambodia. Bombing raids happened into Cambodia to disrupt the Ho Chi Minh Trail. So, and guys, if you didn't know where Cambodia was, here is Cambodia. It is right on the border of Vietnam. So this had been going on for a while, and there were multiple incursions into Cambodia. It was an expansion of the Vietnam War. Now, the Cambodian campaign was undertaken without anybody knowing about it. It was a secret operation. But it was done with it wasn't just like commandos. It was the entire military went all in. So there were things that were passed. So like there was the Cooper Church Amendment, which tried to defund the invasion. And there were things that had gone on and on and on and on. And by 1973, Nixon began an extensive bombing operation over Cambodia called Operation Freedom Deal. And by 1973, Congress had voted to stop all bombing in Cambodia and all operations in Cambodia. They voted to stop all the operations in Cambodia. Then what happened there? Well, as this went on, Nixon vetoed the bill, and it failed. Eventually, Nixon and Congress passed the Case Church Amendment. And this time frame, 1972-73 in the Vietnam War, is very, very interesting. If you guys never learned about it. So they went ahead and they agreed to stop bombing by like August of 1973. In the meantime, a Brooklyn congresswoman sued the Secretary of Defense to stop it. And she went and found a district judge in her congressional district in the Eastern District of New York to put an injunction out there. Notice, this is like the first time we really got Hawaii judge. At that point, he had a permanent injunction stopping the military from releasing any bombs into Cambodia. Now, the Second Circuit was like, yeah, we're going to put that on hold. We're going to put that on hold. We're going to stay that. So after that, which means it could keep going, she then went to Justice Thurgood Marshall, and he says, because he was overseeing the Second Circuit, he's like, yeah, I'm not getting involved. And then from there, because the Supreme Court was in recess, she reapplied. This is in chat. This is the funny part. This is the shadow docket shit. She then went to Justice William O. Douglas. And William O. Douglas, he was on, he's also, he is the longest serving justice in history. He's been there for 36 years until he died. So he was very, 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 very left-leaning, very left-leaning. Now, what happened? Well, she met with him, and they met with him at his house, and he promised them a hearing. Now, he was out in the Ninth Circuit, so he held a hearing himself at a federal courthouse. He was riding circuit, so he did this like the old school way. He went to a federal courthouse in Washington, and he enjoined the government. He enjoined the government from doing this. The military said, fuck you, we're going to do what we want. And then 6 hours later, the rest of the Supreme Court was like, we need to fix this. So what did Thurgood Marshall do? He stayed the injunction himself. Remember, he was in charge of the Second Circuit. So he effectively said, nah, I changed my mind. We're going to stay the injunction. Because at that point, he hadn't done anything with it. It was just sitting on his desk. And he was like, fuck, I don't want to mess with this. So he stayed the injunction. And the way that goes down, according to history, is Thurgood Marshall went ahead and talked to the rest of the court, the other 8 justices, and were like, if I do this, we don't have to convene and we don't have to have a problem. So what happened? Well, Thurgood Marshall neutralized the issue without having to formally reverse this justice's order. Now, what happened out of this? This also led to the War Powers Act being passed and different other things that occurred. So there's quite a bit that happened out of this, where the president needs approval if he engages in military action, things like that. So the War Powers Act happened. But the Supreme Court had to deal with a massive crisis. And think about that, a lone justice going full psycho. That's bad. That's bad. So are Thailand and Cambodia still bombing? It sounds like things have stopped right now. Mindset helped broker the peace deal. So they point out that they just keep going here, and they bring up that, um, what do we do here? They point out that finding the United States had no constructive custody at CCOT. Boasberg itself stressed that El Salvador had chosen to detain the plaintiffs for reasons outside the kin of a district court, meaning outside of my authority. They already did that. They had their own reasons for holding these guys. And even Boasberg admitted that. So they say in its order to show cause, the district court itself disclaimed that 2 of these 3 commands were referenced. It stressed that it never imposed any freestanding requirement to turn planes around. Yet it did. And it repeatedly denied having imposed any overarching requirement to return members to the United States. Except it did. But at the TRO hearing, the court expressly required that class members already expelled need to be brought back. And there's some way out. Yes. And then, yes, this statement can't be reconciled with its later statement at the contempt hearings. The TRO only prevented transfers. Notice these things don't match. They contrast. They conflict. So what does this mean? Well, you have to put aside whether an oral injunction can ever be binding, despite some authority that cannot be. I mean, that's a very big deal. And they say, at a minimum, when an injunction is supported by both oral and written statements, you must focus on the written statement. And the Federal Rules of Civil Procedure contemplate the issuance of an order to ensure that you receive explicit notice of what is being outlawed or prohibited. And they say by the time of a show cause order, the court here, meaning Boasberg, had changed its mind about the oral order to bring back to the United States any members. And it says, likewise, it strongly disclaimed having imposed any obligation to turn the planes around, which he did that because he realized, oh my God, I look like a fucking idiot. So this is the problem here. And it says, perhaps so, but this makes the wholesale omission from the final order important. The district court had promised a written order memorializing all of the operative commands. So when it did and it left things out, well, great. You left them out, Judge, so I'm stuck with what you wrote. And it says that, and once again, they talk about the judge pointing out that once they're out of the country, I'm not sure what I can do. And then one of the cited cases suggests the court could not have afforded relief even before they were transferred to El Salvador. And it says none of this unambiguously resolves whether the prohibited removal turned on a custodial or territorial standard. So you don't fucking know. And they say one final consideration says that, over the course of the day, the district court entered removal simply prohibiting removal. So at a minimum, the contextual clues cut in both directions. Like, what are you supposed to do with this? And publicly available sources for construing that binding text, ordinary diction meanings, legal usage and governing statutes, and the court's own usage in a related earlier TRO all support this idea that it was all about removal from territory, not custody. And they say in construing the whole order, where else would one begin other than considering what removal means under the ordinary usage, under the AEA, and also the INA? And I think that's a very good point. Like, what else are we supposed to look at, man? What are we supposed to look at here? Hold on here, chats. Yeah, hold on one second, chat. Not a shower text. This is important. All right. Sorry. So they say for purposes of criminal contempt, it was ambiguous. Like, how the hell do you comply? Now we have to get back to the Matt Damon standards. Well, the answer to all questions that they brought up earlier were yes, it meets. I'm buffering. I had to answer a text. So the first thing you have to do is whether it's clear and indisputable. Yeah, it's pretty straightforward enough. You know, as explained above, it's clear and indisputable. They're saying that it's not to suggest that this is indisputably correct. There is surely some force in the district court's broader custody-based interpretation, but in the criminal contempt context, merits a question is not which interpretation is the best. Instead, the question is what the TRO covers after resolving any ambiguities. And the dispositive question, guys, remember Wright and Miller. Wright and Miller is we talked about that. That's the civil procedure handbook. It's the Bible, basically. You know, and on the dispositive questions, the TRO seems to me clearly ambiguous, which makes contempt wholly inappropriate. They say, so addressing it, we must consider whether the government has any adequate means for requesting relief at a later stage. Well, here's the problem. For criminal contempt, a final judgment would be one that gives specific unavoidable penalties. And they say interlocutory orders can warrant mandamus if they interfere with the co-equal branch's ability to discharge its duties. And in particular, there have been mandamus when things interfere with the conduct of foreign policy. And they just keep pointing out the problems here. They say immediate review is appropriate for staving off of a looming constitutional confrontation. And they talk about the Cheney case, and in Cheney, the Supreme Court set aside a discovery order directed at Dick Cheney and targeting the process through which he and other senior officials provided advice to the president. And the court acknowledged the government could obtain judicial review by asserting privilege later on. But it held that mandamus was appropriate because the claim of executive privilege is an extraordinary assertion of power that would place the executive and judiciary in a collision course, meaning that even if they had done that, there would have been this clash eventually over whether or not it's appropriate. And then when that judge says, no, you don't have that protection, what are you going to do? What are you going to face? Well, now you're going to have the showdown anyway. They talk about the Peru case here, and they say that the Secretary of State had undertaken to settle claims against the vessel by diplomatic negotiations. And he had asserted sovereign immunity on behalf of Peru. Nonetheless, they denied Peru's request to dismiss the suit on immunity grounds. And rather than wait for the appeals to happen, the Supreme Court granted mandamus without requiring Peru to apply to the circuit court in order to avoid embarrassing the executive arm of the government in the middle of foreign relations discussions. And they say the imposition or threat of contempt can further support mandamus. They talk about Nixon versus Sirica. You know, the court invoked mandamus to review a grand jury subpoena served on the president. And it says to obtain review of a subpoena, most parties must defy it and then appeal the ensuing contempt. But we gave review because in the case of the president, contempt of an order would be a course unseemly at best. Meaning we don't need the governor, we don't need the president defying court orders. That would just look really bad. And it says, although contempt order is not appealable, the Second Circuit granted mandamus to set aside an order that held the attorney general in civil contempt. And it says a contempt sanction imposed on someone in their official capacity is greater public importance. And with separation of powers overtones, it's very important. It's very important. Once again, it's very critical. And they say this order qualifies for mandamus under these principles. The defendants in this action include the president and 3 cabinet secretaries. The underlying dispute arises under national security and counterterrorism interest. Its execution involved 2 foreign sovereigns, Honduras and El Salvador. The district court had found probable cause of some of the involved individuals, likely including those in the closest proximity to the president, committed criminal misconduct. And as explained below, the terms of the order ensure further conflicts between the branches. And notice, and we just mentioned this, it causes more problems. Do something else or I'm going to hold you in contempt. Violate your constitutional duties or I will hold you in more contempt. So the show cause order gives the branch an ultimatum. Either assert custody or face a court-ordered prosecution. Both pathways are constitutionally fraught. And first, the order uses the threat of sanctions to pressure the executive branch into asserting custody over aliens who, in the district court's view, were removed in violation of the TRO. But as Judge Rao explains, the Supreme Court vacated the TRO, so the district court cannot seek to prospectively enforce it all. And it says, whatever the court seeks to pressure, the assertion of custody for people now outside the United States is also problematic. The court is warned in cases involving immigration that courts may not intrude into foreign affairs or matters of national security. And notice that's Biden v. Texas, Arizona versus the United States. Yes. Remember that. Texas and Arizona can't do what they want. And it says, to be sure, courts must seek to vindicate the due process rights of aliens to challenge AEA removals. And that's correct. They have to. The courts must allow that. But to assert custody over aliens outside the custody of the U.S. is to assert the branch has the power to produce them to a United States court. And remember, this then gets to that would involve effectuating rather than just facilitating. Remember, we had that issue about remember, as in they talked about in Trump, what's effectuating and what's facilitating. And it says the judiciary does not have unbridled authority. Remember, this is Trump v. Casa. And we talked about this. Remember, Barrett said, listen, Ketanji, Brown Jackson, you can't fucking do this. You're insane. And it says, for the question to bring in these aliens, it is vitally and intricately interwoven with contemporaneous policies for foreign relations, the war power, and the maintenance of a Republican form of government. Such matters are so entrusted to the political branches as to largely be immune from judicial inquiry or interference. And it said, even when El Salvador was doing this, asserting custody would require the United States to engage in diplomacy to effect a transfer or constructive custody, which courts may not do. But Boasberg did it all anyway. And now the court's order would pressure some level of engagement with the regime in Venezuela that the United States does not recognize. Yes, we recognize Juan Guaido as leader of Venezuela. So is that what he wants? Is that what Boasberg wants us to do, is now engage with a communist government? Well, yeah, it does sound like that. Once again, chat, judicial insurrection. They are the coup. And moreover, it's unclear the United States could even obtain custody over these detainees who wish to remain free in Venezuela. And they said this brings us to the question of what the show cause order pretends absent any purge. And it says, absent a purge, the district court promised a court-directed prosecution. First, the court said it will conduct discovery into which officials decide to transfer. It said once those officials have been identified, it will oversee a criminal prosecution. And it says after the detainees were transferred, the court confirmed that it will follow up with contempt, and if this court lifts the administrative stay. This promised prosecution has its share of difficulties. For starters, discovery is problematic. The government has already asserted the state secret privilege. When you're dealing with foreign terrorists pursuant to international agreements. And moreover, the extent to discovery touches on the communications. The presidential communications privilege might apply. An invocation of privilege that would set the president and Boasberg needlessly on a collision course. It says further problems would arise once the court identified the putative contenders, because courts are not required to exhibit a naivete which ordinary citizens are free. One may safely assume the executive branch would decline to prosecute itself in the circumstances of this case, which it then would appoint its own private attorney, which has its own difficulties. That courts have the inherent authority to initiate contempt proceedings for disobedience, and the authority which encompasses the ability to appoint private attorneys to prosecute. But that holding is hard to reconcile with that court's more recent insistence that the executive branch, not the judiciary, makes arrests and prosecutes offenses on behalf of the United States. Now, notice that is the big one here, guys. The United States v. Texas during the Biden administration, and that's what the Biden administration wanted. Then also Donziger versus the United States. Stephen Donziger is a very, very... He got prosecuted privately. It was a private prosecution. That's one maybe you guys might be interested in. It's all over now for him. But he was an environmentalist lawyer, and he got fucked overall the way it all went down. But we might talk about that one day coming up. And they say, so in any event, they say that Young acknowledged the prosecutor must be disinterested, and decisions regarding the prosecution, therefore, must be all made outside the supervision of the court. But then who would supervise such a prosecutor? If nobody did, the prosecutor would be an unconstitutionally appointed principal officer. And if the court-appointed prosecutors must be subject to supervision by the Attorney General, as the Second Circuit held in Donziger, then the private prosecutor route will be as futile as it is proactive or provocative. Is it Donziger versus Chevron? Yes. All of the oil companies went after that guy. And it said, finally, this court is committed to punish the branch for violating an order that it lacked jurisdiction to enter. The Supreme Court vacated the order because the claims raised, however styled, fell in the habeas corpus petitions. They say, accordingly, the proper respondent to sue was the detainee's immediate custodian, the head of the facility, not some remote supervisory official like a cabinet secretary. And the proper district was Southern Texas, not District of Columbia. And it says the Supreme Court has been unclear whether these rules reflect considerations of personal jurisdiction or venue. They say the government did not press this objection as a ground for mandamus, but the government did raise and prevail on this jurisdictional argument and the underlying case, so it would remain live in any attempt going forward. And they say the impact of jurisdictional defects in the contempt proceedings is unclear. Many cases hold that a court may not impose contempt for violations of an order that it lacked no jurisdiction to enter, because there's civil contempt and criminal contempt, and they're different. They are completely different things, chat. Civil versus criminal. They are entirely different. You guys see Dolezal? No, it's So, but the criminal contempt is big because Boasberg was going to put people in fucking jail. Now, they point out that when a court in the United States undertakes by its process of contempt to punish a man for refusing to comply with an order the court had no authority to make, the order itself being without jurisdiction, is void, and the order punishing for the contempt is equally void. Well, it sounds like fucking Boasberg should have known this shit. Two subsequent cases arguably weaken this rule, although neither purported to overrule them. And they say several circuits still recognize the traditional rule. The 11th Circuit, the 9th Circuit, for example. They say in rejecting this view, the district court rested primarily on Wiley versus Coastal Corporation, which held courts may impose Rule 11 sanctions even in cases where they lack subject matter jurisdiction. And that's a little different. They argue the sanctions are collateral to the merits, so judges may require those practicing before the court to conduct themselves in compliance with procedural rules while a case remains pending. Well, this is a little different. Indeed, the matter at Wiley was a monetary sanction of counsel's careless pleading. It's very different from a significant cross-border national security operation. So in sum, the show cause order would provoke many grave conflicts between judicial branch and the executive branch. And it says, and the executive should not have to wait until the district court has imposed sanctions to raise that objection. In circumstances much less fraught than this, courts have afforded mandamus relief to resolve the dispute. And in such situations, a final appeal is not an adequate remedy. And it says, for the same reasons, mandamus is appropriate. As explained above, the Supreme Court have afforded review through mandamus when a lower court has encroached on a foreign policy, prosecutorial, or other prerogatives. And it says the show cause order does that. It prosecutes threat of criminal prosecution and pressure the branch to exert power over people it no longer has control over. The immediate review is plainly warranted. And then from here, the district court was placed in an enormously difficult position. Faced with an emergency situation, now this is them saying, you fucked up, but it's okay. We're giving you cover. It had to digest and rule upon novel and complex issues within a matter of hours. In that context, the court quite understandably issued a written order that contained some ambiguity. It quite understandably made oral remarks that it later had to walk back. Yes. The proceeding does not concern the lawfulness of the removals on March 15th and 16th, nor may we decide whether the government's implementation warrants praise or criticism as a policy matter. Perhaps it should warrant more careful judicial scrutiny in the future. Perhaps it already has. Remember, those AARP cases are in front of the Supreme Court in AARP v. Trump. Regardless, the government's initial implementation of the proclamation clearly and indisputably was not criminal. He says, I concur that the petition for mandamus vacates the contempt. I would also terminate the criminal contempt proceedings. And that's from Judge Katsas. Now, there's 80 more pages of 70 more pages of stuff. We're not going to get to that. We're not going to get to that chat. It's been a lot already. But what do we have? Well, there's some good stuff that has come up. Chad Mizell, Chief of Staff of the Office of Attorney General. Chad Mizell is a lawyer. He has served as the Chief of Staff to Pam Bondi. He is. Here we go. He is the Chief of Staff, and if you guys haven't seen him before, he is also. He has his own. He has a Twitter. Which is kind of hilarious. So when you see Chad Mizell, this is him. He is the Chief of Staff to the Department of Justice under the leadership of Pam Bondi. And this is him right here in the background. Like, this is just so crazy. We have, like, so many people now are involved. They have Twitter accounts. And this guy's Twitter account here, he talks about all the stuff he's out there. He says, to recap for those not following along, let me give you a timeline leading up to this huge ruling. And it says, Boasberg predicts the Trump administration will violate the court orders. A few days later, Boasberg serendipitously gets a case involving the removal of the most violent members of an FTO. Boasberg issues an injunction and is promptly flipped by the Supreme Court. He lacked jurisdiction. He now concludes the Trump administration violated his unlawful injunction. The D.C. Circuit stays his probable cause finding. And now here's the issue. In the timelines of this, if the contempt comes after it's over, then yes, I agree. If the contempt... Hold on. Oh, no, Clyde is in trouble. Him and Laney just fought. Uh-oh. She just yelled at Clyde. Boasberg now concludes the Trump administration violated his unlawful injunction and proceeds to hold the government in contempt. If the contempt happens after SCOTUS rules, it's bullshit. But my understanding was contempt was before the SCOTUS ruling. Because if it's already existing, then yes, it's fine. But if it's after, then fuck him. The D.C. Circuit stays the probable cause finding. He next issues a preliminary injunction holding removal of those aliens violates due process. And remember, we talked about that. Immediately, he goes around and fucks around. The D.C. Circuit issues an administrative stay of that ruling. Boasberg complains the D.C. Circuit is taking too long. They promptly vacate the contempt finding. And they say, and this is where he talks about what just happened today. It says, if judges want to be partisan political actors, Congress should treat them as such. And I agree. I agree. So there you go, chat. There you go. And what did this lead to for Boasberg? Well, Chad Mizell fucking got involved. And I don't think it's going to go anywhere, but it is fucking very good. There is a... Oh, chat. Here you go. Where's everybody who wants the rule of law now? Remember, we're people who want the rule of law in constitutional crisis. Where are all those people? Where are all those people now, chat? I'm not going to name names, but they know who they are. It's all about the rule of law. Well, where are you guys now? Because it's mighty quiet. Mighty quiet out there. A complaint against the United States District Court Chief Judge Boasberg. And it says, Dear Chief Judge Srinivasan, and this is to the United States Court of Appeals for the District of Columbia, because this is who oversees things. It says, pursuant to 28 U.S.C. 351A, Rules 5, 11, and 20 of the Rules for Judicial Conduct and Judicial Disability Proceedings, and at the direction of the Attorney General, we submit this complaint alleging misconduct by Boasberg for making improper public comments about Trump to the Chief Justice of the United States and other federal judges that have undermined the integrity of the impartiality of the judiciary. So this is where it gets good, chat. On March 11th, Boasberg attended a session of the Judicial Conference of the United States, which exists to discuss administrative matters like budget, security, and facilities. While there, Boasberg attempted to improperly influence Roberts, Chief Justice Roberts, and roughly 24 other federal judges by straying from the topics to express his belief the Trump administration would disregard the rulings of federal courts and trigger a constitutional crisis. He's missing a double space under the letterhead, but that's okay. Yeah, well, you got to deal with it. Although his comments would be inappropriate even if they had some basis, they were even worse because Boasberg has no basis. The Trump administration has complied with all court orders. Remember that. There have been none that have been defied. Trump has complied. All the fucking tampon wringing and hand wringing over that. Nope. They always complied. Nor did Boasberg identify any purported violations of court orders to justify the predictions. And within days of those statements, he began acting on his preconceived belief the Trump administration would not follow orders. First, although he lacked the authority to do so, he issued a TRO restraining the government from removing violent TDA terrorists. And throughout the proceedings, Boasberg rushed the government through complex litigation, sometimes giving the administration less than 48 hours to respond, and threatening criminal contempt proceedings and the appointment of a prosecutor against senior Trump officials for failing to comply with an order that had already been vacated. Taken together, his words and deeds violate the canons of the Code of Conduct for Judges 1, 2A, and 3A6. They erode public confidence in judicial neutrality and warrant a formal investigation under Rule 11. Yeah, isn't this interesting, you guys? Isn't it interesting? Isn't it interesting? So how does that work? How does that work, chat? So, the canons for judicial conduct, chat. Remember, we talked about these. The judges have their own canons. There's a code of conduct for the judges. And here are the canons. A judge should uphold the integrity and independence of the judiciary. A judge should avoid impropriety and the appearance of impropriety in all activities. Respect for the law. A judge should respect and comply with the law and should act at all times in a manner to promote confidence in the integrity and impartiality of the judiciary. And then you move on to Canon 3. And remember, it said 3A6. Adjudicative responsibilities. What are those? I hate it when it does this. When you try to highlight something and it gets all, yeah, see, it's annoying when it does that. Anyways, what does 3A6 say? So 3A6. A judge should not make public comment on the merits of a matter pending or impending in any court. A judge should require similar restraint by court personnel subject to the judge's direction and control. The prohibition on public comment on the merits does not extend to public statements made in the course of the judge's official duties, to explanations of court procedures, or to scholarly presentations made for the purposes of legal education. Crying to Chief Justice Roberts does not count. Does not count. So those are what they are there, and the applicable canons. And they talk about the canons here. We just went through those. And it says the Boasberg's violations. And the Judicial Conference is the policy-making body of the judiciary. It operates strictly as an administrative body focusing on policy matters related to court operations rather than substantive legal issues or cases. Its proceedings are designed to maintain the institutional integrity by addressing only systemic administrative concerns that affect the federal court system as a whole, carefully avoiding discussions that could compromise neutrality or create the appearance of bias. Common topics are court security, budget, administration, facilities, and issues regarding probation and pretrial services. Remember, chat, there are 600 district court judges, and there's, all the circuit court judges. All these judges, and then the other various courts that have Article 3 judges in them. There are a lot of Article 3 judges. So they say at the March 11th conference, Boasberg disregarded this. And it says, by singling out a sitting president who was and remains a party to dozens of active cases, he attempted to transform the routine housekeeping agenda into a forum to persuade Chief Justice Roberts and other federal judges of his preconceived notion that the Trump administration would violate court orders. He not only breached his duties, but he defied reality and the law. First, the Trump administration has complied with every court order. Correct. And then second, including the unlawful orders that appellate courts have subsequently stayed or reversed. Notice he's pointing out, including the unlawful orders that we've had to fight. We've even followed the bullshit you guys made up, which is true. Second, federal courts must have begun from a presumption of regularity, the settled doctrine that executive officials have properly discharged their official duties absent clear evidence otherwise. By predicting noncompliance, he turned that presumption on its head, contradicting both the evidence of past compliance and the governing law. This also leads him to prejudging issues. This comments to the Chief Justice undermine the integrity and impartiality of the judiciary in violation of these canons. By expressing his view, he degraded public confidence in the integrity of the judiciary. Litigants suspect that judges will base matters on the facts and law before them, not on preconceived notions that government officials will violate the law. That's true. It says, worse, these comments were directed at the Chief Justice and other judges from across the country in an apparent attempt to persuade them to adopt his erroneous views. The same judges that will hear other cases involving Trump's administration. And because the Chief Justice would review Boasberg decisions, his remarks are problematic. Yeah. Like, Roberts might have to recuse himself as he attempted to prejudice the very court that would scrutinize his decisions, as it did ultimately in JGG, holding his actions were unlawful. In a recent interview with a law professor, a recent law professor criticized Boasberg's actions using an inappropriate setting to try to get the justice to give his opinion on the constitutional crisis. In essence, Boasberg was trying to entrap the Chief Justice and get him on the record to join him to almost approve what he's doing to spark this fight. Stirring that shit is what he's doing. And it's not mere conjecture to say that Boasberg's comments eroded confidence in the judiciary. It's already happened. His remarks have been publicized and criticized. This is precisely why the canons prescribe this kind of behavior and prohibit it. Yes. Somebody's saying something here. I'm trying to catch up. Where did you guys say something? So these ensuing actions over the next 5 weeks follow the very script he had sketched at the conference. On May 15th, March 15th, 4 days after he made his comments, he granted the TRO. Isn't that kind of coincidental? That evening, he expanded relief to a nationwide class, and we've already gone through that. He then convened an emergency compliance hearing before the government's motion to vacate was even due, suggesting the non-compliance he had predicted 6 days earlier had occurred. Over the next 48 hours, he ordered declarations detailing flight pass and passenger counts. Deadlines so compressed, the DOJ twice sought relief, only to be rebuffed. And this departure from standard practice shows that he was driven by agenda, not facts and law. So they go forward. They talk about his show cause order. And yes, he proceeded to issue a show cause order, 46 pages. And this is undeterred. On April 7th, the Supreme Court vacated his class-wide TRO. Despite that, he issued a 46-page show cause opinion, threatening criminal contempt. Since then, the D.C. Circuit has recognized his errors, staying it twice. These facts together show Boasberg's actions have harmed the integrity and public confidence in all of this. His comments on March 11th appear to have been improperly implemented from the bench. And this violates trust in an impartial judiciary and falls below standards that safeguard the integrity of judiciary. So what do they want? Well, they want relief here. They want to docket and refer this complaint to a special committee. Well, that's not going to happen. And they determine whether his conduct constitutes prejudicial and effective and expeditious administration of the business of the courts. Not happening. Order interim corrective measures during the investigation, including reassignment of all related JGG cases to another judge. Not happening. Upon substantiation, impose appropriate disciplinary action, including a public reprimand and referral for consideration of impeachment-related recommendations. If there's willful misconduct, not happening. As much as we like that to happen, chat, it is nothing happens o'clock. So Boasberg publicly forecasted his predictions of lawlessness and then issued erroneous rulings based on that. So they say swift visible action will reinforce the judicial integrity by showing judges are held to the same standards they enforce and deter comparable misconduct. This says respectfully, Chad Mizell, Chief of Staff, the Office of the Attorney General. So what's that mean? Well, chat, would you look at the time? It's nothing o'clock. Nothing's going to happen. As much as it should, Boasberg is a piece of shit, but nothing's going to happen. Chugi Show says 1 year and old, but hasn't learned to be on time. Well, thank you, Chugi. Sweet Tooth Fairy's been a member for 28 months. Thank you, Sweet Tooth, for that support. 28 months. Oh, cool numbers, cool numbers. Happy birthday, blogger. Plus 2 days. Well, thank you. Emily Allen, 4177, because there's apparently 4,176 of you out there already. That's a lot of you on YouTube. It's been a member for 2 months. Thank you for being here. It says, love me some live. Happy Tuesday. Well, thank you. Thank you. Jeff Chapeau says, courts are so creative in writing. You're stupid. Yes, they are. Henrik is saying, what's at stake as Trump prepares to meet Putin in Alaska? I mean, the idea that Trump may send all kinds of equipment to Ukraine is really like the biggest thing right now. But given the collapse of the Ukrainian army in certain sectors of the front, I don't think it's going to matter. And in reality, no amount of equipment would change the fact that the Ukrainians have had hundreds of thousands of deserters. Whether or not they're padding their stats of wounded and dead with desertions, we don't really know, but things are not looking good for the Ukrainian military. So regardless. But also, Henrik, good to see you, man. Hope you're doing well. 10K view says cats and meow. I guess. Coke Fairy says, hail chat. Well, how are you, Coke Fairy? Hope you're doing well. Henrik says, Russia does not want Europe. The cost to operate the largest mental ward there leaves it cost prohibitive. Very true. Very true. Very true. Cleopatra says, just because the judge orders it doesn't mean they'll do it. The night smacked down California's ammo background check, and the California DOJ said they'll still uphold it. Yeah, I mean, that becomes the issue of then, well, enforce your order. So, John Coleman says, I'm sorry, son, I'm late and gay. Well, that's okay. Sometimes we all are. P-Dub is saying, didn't it come out that per DC Appellate Circuit, oral orders have no authority, and only the written order is binding? Well, no, that's just generally how courts treat it, period. If there's a written order, that takes precedence over the oral order. The written order is the one that controls. That's generally just how it goes. But I think we probably already got to that covering it. Tech Guy South says Boasberg. More like Toastberg. Am I right? Yeah. T from Laos says the weird thing about Laos is 9% of the population lives in 10% of the country. Yes. And Laos is still home to a crazy communist government. And Laos also has a ton of landmines that are still there from the Vietnam War. It is very, 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 very weird how it all works. It is a People's Democratic Republic. And yeah, it's very interesting there. You know, the Laotian People's Revolutionary Party is the sole ruling party there, and they are 100% communist. So yes, that is yeah, Laos has had a, you're Laotian, you've had a rough time. And then Bob Johnson says, Marley Matlin, in our words, we all have to def talk. Yes. Oh. Yeah, you Laotian, ain't you, Mr. Khan? So is Laos the Canada of the East, kind of? Some Laotians. Our best tower builders are in Alligator Alcatraz. Oh. So. Am I going to cover the Laura Loomer depositions against Bill Maher? Yes. The transcripts are out right now, but I hope there's like some other stuff getting released on that because I don't want to do it. I don't want to just do that. But yes, apparently Laura Loomer fell apart in the depositions, just acting like a complete asshole. Shocker, I know. Shocker, I know. On that. And then real quick, ammo is currency. Good Shredder S07. Shredder S07 says word on the street is the WNBA is going to mandate crowd nets to prevent tossing true fans from tossing toys onto the court. Yes. Yes. The WNBA is going to put up netting like a fucking hockey game. Which is very funny. But yes, it is going up, chat. This is, if you guys are not seeing it here, yes, that's off Twitter. The WNBA is installing netting. Oh. Uh-oh. Uh-oh. I do like Smash JT's comment of like, new challenge unlocked. And then I do like this. Yes, it is very much. I love this guy's laugh, by the way, in the meme. But yes, they're installing nets to protect against dildo throwing, which means you're going to have to do some arcing shots in chat. You have to do some arc shots in there. But thank you, Shredder, for your super chat. I appreciate it. Oh. The bitch looks like Jigsaw. Goddamn. Yes, Laura Loomer is awful. And Laura Loomer got in trouble recently. Well, on Friday, she started talking about Florent Groberg and talking shit about him. And Florent Groberg is a living Medal of Honor recipient from Afghanistan. He tackled a suicide bomber as he attempted to detonate and kill his platoon or parts of his company. And she started talking shit about him because for some reason She didn't like the fact he's a Democrat, which, okay, he has the right to do that. And it turned into an absolute dumpster fire for Laura Loomer, which rightfully so. I'm pretty sure the fans will still be able to get toys on the field. The fans are for better shots than anyone in the WNBA. Well, that's true. That's true. Oh. Punch the Dirty Roofer. How you doing, man? Yes, I do like your sign. Big booty Latinas could stay. That's so. Alex Stein may have changed his mind there to protect it. WNBA puts up netting. Frat boys everywhere. Challenge accepted. Yes. Yes, that's very true. Where there's a will, there's a way. Another for $5 says, are you Chinese or Japanese? No, Mr. Khan's Laotian. No, like I said, there's some great King of the Hill stuff out there. Not the new stuff, though. Angry Cops had a good video about Florent Groberg the other day. Yeah, I saw that where he went after Laura Loomer, and it's like, those guys have fun with her. I just think it's funny so many people are learning she's a fucking idiot. So, Ronald McDonald says, Nick Rekieta told me it was legal to throw baldos on the court, Sean. Well, technically, it's not a dildo, it's a baldo. So, yes, I would argue that's okay. They should play in lingerie like that football league. Yeah, but they're lesbians, so they don't. Yeah, it's not good. Might make better numbers. You want to see Brittany Griner in lingerie? Go for it, man. That's all you. Torgo the White says that is a parody account, no netting. Oh, is it? Oh, I thought it was. Is it not? Oh, chat, I'm sorry. I did fake news, chat. Your dildo throwing will be unobstructed. My apologies, chat. So, there you go. So, okay, so yes, there is a note here. NBA Sentinel is a parody account. This is not a true story. Well, for now, until they start making dildo nets. My Baldo launcher would get through that. Yeah, 40 millimeter Baldo launcher. I'd have to bring it in there, though, and I'd be like, thoomph, open it up, clink, pull out the casing, shove in a new one, thump, click, thoomph. Start pelting them with dildos and Baldos. Like dildo buckshot. Oh. Not to defend Loomer, but I met several. And most of they're good dudes. Just because you earned it doesn't mean you're immune to being a piece of shit. I don't disagree with you, Nero. But the idea was Laura Loomer was complaining because the guy was speaking at a Democrat organization, which, he wasn't in there saying, let's cut off little kids' penises. He was just, he supports the Democrat Party. Like, okay, he's allowed to do that. Laura Loomer is just being a faggot. That's all she was doing. So, Torgo the White says that is a parody account, no netting. Well, thank you. Yeah. Reddit says Trump is a cunt. Well, he's our cunt. Smog and Moggin says it is perfectly legal. There is no law against. Yes. Then EDW Raptor says on a scale of 1 to 10, with 10 being the highest, how hard did Dan Carlin crash out? Yes, chat. Dan Carlin, hardcore history. Oh my God. And this is where we'll cover another thing right here. In response to the lawlessness in D.C., Trump has ordered the National Guard to augment the D.C. police and are now patrolling the streets of Washington, D.C. So they're now showing up, helping take care of problems because the city's just fucking lawless. And they're on the streets being involved and wanting to get involved. There's over 800 Guard members that have been mobilized, and about 850 officers and agents took part in a massive surge. And now they point out the violent crime rate in Washington, D.C. is at a 30-year low. Yeah, it is. That's great. Okay. The total violent, like, it's at a low, but what does that low mean? What does that low mean at the end of the day? Because when you talk about, like, how many murders were there in DC in 2024? You know, it's a lot. Um, you know, this is so funny. As this goes here, and the coping and the pissing and shitting of the left here, these are just absolutely amazing at this point. So I hate it when it does this. I hate it when it does that. God, it's so annoying when the header is there. So Trump claims that Washington's murder rate is higher than Bogota or Mexico City. And you notice they go, here's what those stats say. So he's claiming that it's really bad here. Okay, well. Mayor Bowser claimed the decision alarming and unprecedented. But what happened? What do the numbers say? So the DC, the District of Columbia, has a homicide rate of 27.5 per 100,000 inhabitants of Washington, D.C. A figure that, according to him, would place it above Bogota, 15 murders per 100,000 inhabitants, Panama City, 15, San Jose, Costa Rica, Mexico City at 10, and Lima, Peru. Okay, well, it sounds like he was right. According to these stats they're gained from organizations, they seem to confirm Trump's statement. Washington has surpassed several Latin American capitals. Although this is only one of many other crime rates. Notice, these motherfuckers are now trying to claim it's okay that not everybody's getting murdered. It's not that big a deal. It's not that big a deal. There's a more nuanced picture. People are dead. According to CNN journalist Daniel Dale, the crime in Washington has increased from a spike in 2023 when 274 homicides were recorded, the highest number in more than 2 decades. Okay, so it's gone down. What has it gone down to? In 2024, it went to 187. 187. 187. And the Washington, D.C. is 68 square miles. And 10% of that's water, so it's only 60 square miles. I mean, chat, you need to understand that. This is last year, there were 180. Well, and here's the interesting thing about this. Most of the reporters and stuff like that, most of the people who don't have problems live like here. You basically have 187 murders in this entire area here. The rest of this had 187 murders in it. Think about that. Think about that size, 187 murders. And Anacostia Naval Station down here, Anacostia in the Naval Yard, this whole fucking area right here is really fucking dangerous. This whole area right here is notorious. That's where AOC lived. That's where some people have been attacked. Congressmen have been attacked. And notice, they're bullshitting your way through this. They're saying, it's no big deal. It's no big deal. Yeah, and most of those are in southeastern DC. Yeah, Joint Air Base Bowling has its own problems. Yes. Thank you for being here, man. But yeah, most of this is in southeastern DC. Yeah. Think about how assholeish these people are. Well, it's only 187 murders. And so far, they're going to decline even more. That homicides fell 30% compared with 2023 through July of this year. Furthermore, the violent crime in 2024 is the lowest since 1966. That's not good. I mean, it's good, it's low, but how bad is it? How bad is it that that's going on? Since 1966, it sounds like it's really fucking awful there. Yes, MLK Avenue is in southeastern DC. These people are fucking... The Fifth Estate is full of revolutionary communists that undermine everything. The overall crime has decreased in 2025. It's still an unacceptable level. Even if it went down to 100 people being murdered in D.C., that's still a lot. So notice that. Notice that. We're more fucking violent than Bogota, Colombia. You know, fucking Pablo Escobarville. Panama City, Panama. Fucking Costa Rica. Mexico City, where people get their heads cut off. Lima, Peru. And then Brasilia, Brazil, although that's out in the middle of nowhere. But notice, it's worse here than it is in fucking Bogota. What is going on here? What is going on here? Yeah, the highest crime rate is in Capitol Hill neighborhood of DC. Let me see if I can find that real quick here. Where is... let's see here. Where's Capitol Hill? But these are all the... Guys, going back to this, these are all the neighborhoods of Washington, D.C. So, but anyways, you can see here things like Foggy Bottom. That's where the State Department is. You have the mall. You know, here's like the Ellipsis and all that stuff. You know, you have like Georgetown here. If you guys have never wondered where all this stuff is, that's all right there. Where the hell is Capitol Hill? On the... Yeah, right here. Capitol Hill. This is like the most dangerous area in Washington, D.C. Maybe not right next to the Capitol building, but notice all this shit around it. Then you have the Navy Yard, really dangerous. Anacostia Park, really dangerous. Anacostia itself, very dangerous. There's a lot of fucking dangerous places in fucking DC. Very fucking dangerous. Like, you got to be very, very careful around there, chat. It's not to be confused with Foghat. Yes. Bushmaster said, I have fatigue. We all do have fatigue. DC is right next to Baltimore, Murderland. It's not right next to it, but yeah, it's pretty close. It's close enough. It's close enough. It's close enough. If you guys don't know, here is the map of Maryland. Guys, remember, here's Maryland right here. Here's the Chesapeake Bay. Here's Maryland. That's Maryland right there. So instead of that, we're going to focus on, well, where's DC in relationship to Baltimore? Baltimore is just down I-95. You can get there pretty quick. So from Baltimore to DC, I mean, you can zoom in together on them. You know, here's Baltimore, Murderland. Here's Washington, D.C. And then here's the Potomac River. That's down below this is Virginia. This is VA. And then you have D.C. Then this is Maryland. And then this is I-95. Right into Baltimore, Maryland. Not very far away at all. Then also, look, here is the bridge. I don't know. It doesn't show the bridge knocked out. That's interesting. Google left it up to lie to us, I guess. But up the Patapsco River. Interesting. Interesting. Interesting that it's still there. So, I still think that was very sus what happened there. Very, very sus what happened there. Anyways, if you guys don't know what Anacostia means, there's the Anacostia River. And there used to be naval, you know, the naval yards, everything here. There used to be like the Navy had significant infrastructure in this area. Okay. And then here's Joint Base Anacostia Bowling. That is another base in the area. And remember, this is Reagan International Airport, and this is where the helicopter was flying along. And that's when the airplane came in and they crashed right there. So there's that. There is that. Demon's Wrath says, oh, our noggers are more powerful than their noggers, Sean. I don't know if I want to have a nog off. I think they're saying that the criminals in government are the worst, maybe. Stacy says, my nephew went to Gallaudet. Gallaudet, guys, if you aren't aware, is a university for deaf people. It's famous for being that way in the country. It's for deaf people. And they actually had it's called Militant Deaf is a movement. And at Gallaudet, they actually had a whole thing about, they demanded that their, the president of their school, the president of the college, they demanded a deaf president. It's a big deal there. Yes, it's a very interesting setup they have there. DC has the worst hood surrounding the DC area. If you saw it, you'd be sick to your stomach. We lived right outside of Andrews. That's true. That's true. It's really fucking rough. AT1 says it's 2 hours by car from Baltimore. Yeah. Yep. McNulty is retired. Don't wake him. Yes. It could be 30 minutes with no traffic. I mean, I could see that, but you got to get there. That's the problem. You're hoping there's no traffic. I don't know if you can guarantee that. That's not a fair. That's not a fair thing there. Also, how far is it from me to Baltimore? It's only 6 hours to Baltimore, Murderland. So then we need yeah, in Washington D.C. it's an hour by car, but I'm sure that takes a lot longer if there's traffic in the way, because I-95 is busy. We camped on the Potomac in Girl Scouts. Yeah, not anymore. Not anymore. No. Sounds like segregation. I mean, I don't know if I lived in D.C., you'd probably want it. Above the bell curve, sign language is cool. Yeah, it can be. Gallaudet, never heard of it. Do they teach echolocation? No, I don't think so at the school. Smog and Mog says, farewell helicopter that fell in the Potomac. Your drawing skills are now your best strength. Thank you for $10. Thank you, man. I appreciate it. Yes, it's 41 miles. Yeah, roughly it is. It is 40 miles from DC to Baltimore. Bud the Bell curses, I got family out there and it's a fucking hellhole outside the little oasis of civilization. Yes, it's fucking rough. It's fucking rough. And the counties surrounding Baltimore aren't much fucking better. Yeah, they teach all classes in English and sign language concurrently. Yes. This is all because Yakub created Whitey. Yes, he did. Years ago, DC was spotless and safe. Yeah. I mean, that's the thing. Now it's so fucking violent. I mean, but it's like that in a lot of places. I've never been to San Francisco. I've never been to LA. I think it'd be neat to go to those places. Problem is, I don't want to fucking go walk around. The fucking violence and the shit and the hobos. So it all happens. It's just ridiculous. Is the school mascot a naked bull rat? Unlike Blossoms, I was thinking of a school for the blind, not the deaf. Well, that's not. You know what though? There are schools for the blind in every state's got a school for the blind. Yes, San Francisco's death by parking meter. I've heard that too. Sergeant Dornan says I have to go to LA on Thursday for work. Well, that sounds like at least you're getting paid. You guys don't think you're getting Clyde today? I don't know. We'll see if hold on here. Give me a second, chat. I'll see if I can get Clyde. I'll see if Clyde's not in jail. Give me a second here. Hold on. All right, chat, we're back. So apparently Clyde lost his peeing privileges. Let me see if he'll come in here, though. Clyde! I hear the click-clacks. Come here, Bubber Bear. We're not going to yell at you here. We just want to pet you and love you and tell you you're such a good boy. Come on, Clyde. Up here. Come on. Hi, Bubba. Ah! All right, chat. Clyde lost his peens. Let's get him some peens. Oh, your claws are a little sharp there, Bubber. Oh, poop. Let's get him some peens, chat. It's okay, Bubba. We love you. We love you. You're such a good boy. You're such a good boy. You're such a good boy. Oh, such a good boy. See, unlike 2.0, we don't punish you here. We just love you because you're such a good boy. Yes. Ah, woo. And you know what, chat? You're getting free of woos tonight. Got to think about them. Ah, woo. Ah, woo. Ah, woo. So, Rip Clyde's peens. Yep. So, yes, he did. Yes, he did. He is, apparently he got a little too aggressive, I guess. I don't know. I don't know what he did. I just know 2.0 yelled at him. So I don't even know if it was justified or not. Was it justified, Bubba? Did you do something wrong? Did you do something wrong? Did you do something wrong, Bubber Bear? Huh? Did you? Did you do something wrong? I don't know. He can get free peens at the WNBA games. Oh my God! That's the best thing we could do. He could be like that dog that goes out and catches the bats at baseball games or the block when they're kicking off at football games. He could go run out and grab the peens and take them back. That would be perfect. Clyde, we can make you famous. Clyde the peen dog. Yeah, I know, but if they're peens, he'll go for them. Well, he'll get them off the court. Clyde the dildo dog. No, wait, that's bad, actually. We're not doing that one. Poor Clyde's going to go to a WNBA game. No, because I would have to go. We're not going. It's okay, Bubba. It's okay. We love you. We love you. Do you really want your doggo grabbing dicks? Well, at least Clyde out to the WNBA. Oh. So, the Peen Rushers Union's looking for talent like Clyde. Yes. What do you think, Bubba? Huh? Huh? Let's get you know what, Clyde, come here. You can lay back. Come here and lay back, Bubba. Ugh. Come here. Clyde, come on. Don't fight me. Okay. You're being ridiculous, doggo. There, see? Was that so bad? You're being so good. All right, there we go. There we go, chat. Uh-oh, what's wrong? There's no food down there. Do you see something you like? Is there something you want to say? Okay. Apparently, Angel Reese blew out her back. Ha! Clyde might grab the wrong dick. Yeah, I know. He might attack Brittany Griner. Pay him what he's worth, Sean. Well, that's you, chat. Pay him what he's worth. Pay him what he's worth. But EDW Raptor said really quick, on a scale of 1 to 10 sandwiches, with 10 being the highest, how hard did Dan Carlin crash out? Like on a 40. That dude lost his mind. It was so funny to see. Graham, it's good to see you, buddy. Why is it saving democracy when the Dems walk out in Texas, but not Republicans in Oregon? I agree. Why is it the case that Illinois is not an example of a violent gerrymandering? Or New York? Or California? Or Maryland? How come those are okay? You know, how come Massachusetts is okay? How come Connecticut's okay? Remember, those seem to be okay. But no, it's just Texas is the only one that's not allowed. Remember, there's a reason why that is. There's a reason why that is. It's okay, Bubba. It's okay. You're okay, Bubber Bear. He's just relaxing. But a very good point, Graham. I agree with you. I 100% agree with you. Give the poor guy a weed treat. Well, I don't know if 2.0 is going to give him a weed treat. I don't have any in here. Do you want a weed treat, Clyde? Huh? Honey, can you give him a weed treat? 2.0. Can you give him a weed treat? No, I don't have any more. I haven't had any more in a while. What? I don't have any more. You're going to have to call for him. So, give us all a weed treat. Yeah, so Clyde's going to go get a weed treat. You're going to get a weed treat, Bubba. Okay? I got you. I got you. Shh. There you go. There you go, Bubber. Nitrous oxide ODs are rising nationwide. Yeah, it's dangerous shit. You shouldn't do it. We should have a ping cam. Yes, the Wisconsin Democrats went to a tilted kilt. Yep, across the border in Michigan. Yep. Maryland's a dumpster fire. Yes, it is. So, will you cover the Dave Moscato trial? Is that going to be televised anywhere? Because that's something we can get into, chat. I don't know. I know he's a lol cow, but I don't know anything else there. I haven't seen if it's going to be anywhere. So, but anyways, he's representing himself. So, I don't know if it's said anywhere. You guys know where it's at. I know it's on the farms, but I didn't see anything for it. Did I figure out the mic? Yes, I did. So it's fixed. And the video's up. Oh, he has a lawyer. I thought he was filing his own shit. So, okay. So, you can go, Bubba. Go for it. Go for it. You're okay. You can get out. Like, he's so weird. Like, if there's anything near on the floor where he comes in, he's like, I can't go away from this. It's like, you walked past it to come in here. So, Uncle Paul Vogel. Yeah. Although it really sounds like, for Bob Vogel, he's like, I dated a girl and she told me she was 19. And now it turns out she was 17. So it's like, and let me guess, he's got naked pictures of her. So now that's child porn. And it's like, yeah, you're not fucking looking good on this one, man. So yeah, it's a rough thing for Bob. We'll see what happens. But I break it down. I kind of explain all the stuff in it. So did I hear about the Long Island yachting death? No, I didn't hear about that one yet. So, Seller says, why is the one lesser charge though? Which is the lesser? I don't know what you mean by that. I don't know what you mean by the lesser. If you're 40 plus 19 should be totally off the table regardless. Yeah, it's fine if you want to do it, but you better be fucking sure that it's 19. There were 3 bad ones. One was a lesser felony. No, there's just count 1 and count 2 are really bad. Producing and then creating obscenities involving a minor. The third one was possessing it. Possessing, what about the child porn? Well, possessing child porn is a lot less serious than if you created it or produced it. It's a far less serious offense. It's still a felony, but that's why one of them is lesser than the 2. So I hope that makes sense. Johnny must suffer in court. 4 p.m. sold time. Be there. Ooh, that'll be good. That'll be good. Yes, there's half your age plus 7 is correct. Is Johnny tonight? Yes. Johnny Somali is tonight. We'll find out what happens to him. The post that says the courtroom is streamed doesn't have a link. I know, and that's the thing. I have to work tomorrow, so if we watch it, it'll be tomorrow night. So, Jordan Bemke says, does it make a difference to the wood chipper? No. What's the difference between creating and producing CP distribution? Well, in Ohio, yes, it's considered like if you're creating it, that's one thing. And then if you're involved in the other parts of it, it's another thing. So. And then if you possess it, that's a completely different matter too. Turtle Boy has a hearing tomorrow as well. Yes. There was a hearing today in the Miles King case. I don't know if that got anywhere. So I'll have to watch the Young Jerks to see if there's an update to it. So Legal Mind says Johnny Somali link. Well, here we go. Yeah. Katie says too many CP questions. You guys are looking sus. Yeah, well, they're asking about cheese pizza. The Montauk yacht death. She was on a rich insurance man's boat for a late business meeting. Oh. Sounds sketchy. Don't know anything about it. I'll have to look into it. I think Somali's homeless now. Yeah, it sounds like Hank cut him loose. So, couldn't happen to a nicer guy. Yes, Karen Reed had a bunch of documents dropped today in her civil suit. Yep. She also got her car and phone back. Which, once again, Karen should fucking sell that car. People will pay for it. So. Oh, KLF is saying the Long Island yacht death was ruled no foul play last week. You seem to know a lot about that, KLF. Very suspicious. Guys, the Karen Reed stuff we'll probably get to on Thursday night. Ultimately. She should put her car on a trailer. Yeah, that would be funny. Is the civil suit for Karen Reed still happening for now? Yeah, there haven't been really any movement in it yet. You make local news, so yeah, well, you're the one making it. Apparently, yes, that is the other thing too. Judson Welcher he bought the same underwear as John O'Keefe for his fucking, not only did he wear the same shirt and pants as John O'Keefe, he wore the same fucking underwear. Any updates on Matt at CRS Firearms? No. I don't have anything right there. I'll talk to Matt LaRosier, though, about that and see what there's an update. His wife had said the channel was stopping, and there's sounded like things for Matt weren't going the best. It sounded like Matt might be sick. Yeah. But the channel is over. So, yeah. Heard he was having a rough time, but he's hanging in there. Yeah, he's apparently he's got the big casino. So that is the case there. His wife is still keeping the channels and stuff going. So, but yeah, he's hanging in there. So why did he do that? Who buys used underwear? No, Lord 8. He didn't buy used underwear. He bought the same type of underwear John O'Keefe used and dressed up fully like John O'Keefe because he's a retard. And, we find out that Trooper Paul came up with this test and then Judson Welcher copied it. That's how retarded these guys were. So, yeah, Matt's had cancer for a while. Yeah. There's a new interview with the MSP head. Peter Tragos covered it today. Yeah, I saw that. I'm like, I'm not going to cover that. The guy's fucking lying about it. Not Tragos. The head of the MSP is just going to be like, yeah, we're going to fix everything. And then shit won't get fixed. So, yes, they did sell John O'Keefe's used underwear. Yes, they did that. I'm sorry. Yes. Yep, because they're fucking creeps. So, all right, chat. Well, I think that's kind of it for now. I think we kind of got everywhere we can go. Let's see. Did I catch everything? Yep, I did. I did catch everything. Yeah, Johnny Somali will be on trial tonight. There are people for Mindset that are going to help him cover it live, and they plan on covering it live very well. There's a whole game plan happening. And let me see here. Yeah, that's really it, though. That's really it. Get some quality sleep. I will be, because I need some. I don't know if I look like it, but I really do. I need to get some good sleep. Clyde Peen stream is when? I don't know. But yes, it's like legal dick suckers, more like it. I agree.
Legal mindset. Legal mindset. Legal dick suckers, more like it.
Very true, chat. Legal dick sucker is more like it. Time for a cooking stream, Sean. Yeah, I'm good. You got to work tomorrow, Sean. I do. Dump to a model stream? No, not tonight, guys. I need to get ready. I got to get some sleep. I got to be... I got called by the court. They asked if I could show up for a emergency... there's a shelter care hearing. The court has asked a couple of attorneys if they can do it. They're all conflicted out. So they call me and ask me if I come in and do it. So I got to be there like at 8 o'clock in the morning to do it. So, yeah, some parents, the agency came in and removed some kids. So mom and dad have the right to have a hearing about that. So got to be there at 8 in the morning, and I got to hit the road at 7. So going to be a long day. So I'm going to go take care of that. And I will see you guys tomorrow afternoon. If we get done and there is Dave Moscato's trial, we'll watch that. That should be fun. If that's the case, we won't do members only. If not, we'll do members only. And then I think there's some things we might be able to cover. I need to take a look at it. I know some people have asked me about, since I've done all the Ethan Klein stuff, what is this case about him and Ryan Kavanaugh about? And we might dig into that tomorrow night. There's a couple of different things we'll look at. So we'll do that. Let's see here. Ronald McDonald says, McDonaldo says, good night, Sean. Well, thank you. You guys all take care. And remember, until next time, just because you did it does not mean you're guilty. Unless you're Judge Boasberg, and then fuck you, you cocksucker. Good night, chat. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes, it was. He